somehow constitutional rights take a back seat. But there are assumptions made here that are concerning to me and that I frankly think are inaccurate. The issue of pretrial publicity, this court has addressed already and will continue to address. I understand that. But the reality is pretrial publicity is a result of what the state has charged and the circumstances on which they base that. Pretrial publicity is not going away. So what is being challenged here is the idea that by allowing or by banning cameras from the courtroom, that it will somehow do away with pretrial publicity. My point, Your Honor, is I don't know how that can happen. And the point that I was leading to was, Your Honor, which is a more accurate description to the public, which is indisputably interesting. Locally,
let me ask you a question.
Sure.
And I have not reviewed the video, and I will do that.
Certainly.
And the parties, and I'm referring to the video, that's the link in a footnote in the state's response page of the last proceeding. But if, as counsel argues, that while arguments are being made by the attorneys, which is what's happening in the case, while that's going on, all the public is seeing is the face of the defendant, then how is that accurately portraying what's happening in the case and not just sensationalizing the case, because you're ignoring what people are saying? They can listen to it, but you're not putting the camera on who's talking. You're putting the camera on the defendant. So as they've argued, and I'll confirm whether or not that's the case, the public can gauge every single reaction for while things are being said. How is that providing accurate information more than focusing on what's being said in the actual record of the case by the lawyers?
And Your Honor, my purpose is not to bootstrap myself into arguing specific camera shots at specific times. My point is, and is to concede that this is within the control of the court. We reject that there was a nefarious motive or even action here because we just complied with what we were approved to do. Now,
and I completely agree with you on that. Okay. I want to make clear, I have found nothing to indicate that any of the media outlets in this case have failed to comply at any time with what they were allowed to do. I guess what I'm looking at this point is the result of what the current order indicates they are allowed to do and whether that needs to be restricted. So I do want to make very clear, your clients have not at any time failed to comply with any court order.
Right, and I appreciate that, Judge, and that is important. But I'm also not trying to address what's been called unfettered access. We're trying to play within the rules. And we believe we are playing within the rules. Now, within those rules, which include the discretion of the court, please understand, I'm not trying to argue to the contrary. Within the rules, if the court determines a different location, a different, somehow with the process needs to be altered in some way, that of course is also within the court's discretion. I do take issue with the idea that because the media has followed the rules and because there was viewing of concern, and we all know that the defendant's reaction to the proceedings is of public interest. Now, whether the court feels that too much of that occurred or not, again, we just want to play within the rules. So, but what I'm hearing is not that. What I'm hearing is, despite the actions of the media as approved by the court, being unsatisfactory, even concerning to the parties, cameras should be banned, period. And the point that I was leading to, Your Honor, is because of the pretrial publicity, which is not going away, which is more appropriate? An actual showing of the proceedings themselves under whatever rules the court determines. And I will come back to that because there are some reasons for why multiple cameras are better and fulfill the decorum of the court that this court has every right to demand and inspect. But is it better to allow the proceedings to be shown in addressing pretrial publicity, or is it better to require someone to be physically in the courtroom so that they have to report on the proceedings? There was nothing about the actions that day that interrupted the decorum of the court. And it was showing, perhaps in a way that the court will adjust, but it was showing what was going on there, including the defendant's reaction. That's my focus, Your Honor, is what we believe is an inappropriately extreme response to actions that were permitted by the court, as opposed to the court just continuing to do what it has done, and that is balance those interests that it recognizes and continues to address that in the way that it deems appropriate. Does that make sense, Your Honor?
It does.
I did not mean to suggest that this court had to do something different, but I do not apologize for the importance that the role the media plays in this, and it is easy to throw out terms. I'm not suggesting whether it's done here or not, it's up to the court to determine, sensationalizing or circus or whatever, in a proceeding that is just like this, except that it had microphones and cameras in places that were approved beforehand. Your Honor, there are some technical reasons that I think it's also important that the court understand. And again, I hope it's clear, there was no intent to mislead. We just placed them where we were told we could. Now, as far as the microphones go, I'm advised that microphones, and as I believe the court knows, Court TV was the pool, providing the pool coverage that day. They have perhaps abilities and capabilities that local media, such as East Idaho News, who has also provided pool coverage, does not have. The locations of microphones and cameras today was first and foremost approved by the court, but also it is the resources that East Idaho News has. Court TV got additional resources, and that includes specific and precise microphones. It is important to understand, I guess, first of all, I will offer this, Judge. Court TV has the ability to provide mutable microphones. However, I also believe that argument is a little bit misleading, because the argument is made that if somebody is arguing at the table and there's a conversation next to them, that this system, the court system, could be muted to avoid catching them. But you can't do both at the same time. You can't make an argument over the microphone in counsel and mute the microphone if there's a conversation there. That's why the level of effort is put in by the media to comply with the court's order, not to find ways around it. There was that day a technical, at least one technical person, perhaps one audio, one visual, I'm not exactly sure, in real time monitoring, so that if a whisper is heard, and frankly, and if they don't know where it's coming from, all the mics get shut down. But if they,
But that person, let me ask you.
Sure.
Right.
Sure.
We deal with officers of the court, who have all of their responsibilities and duties of the court when attorneys are out there. We have clients who have the right to remain silent. What is being suggested here is that a technical person who has some training, I don't know who they are, I don't know who they're employed by, I don't know who pays them. And the suggestion that we outsource the recording outside of our own court-approved system to a third party under the good faith that they won't leak anything out if they capture the wrong thing being said, like a privileged attorney-client communication. I find that a very concerning proposition, and something, quite frankly, I can't imagine I would continue to permit, because the issue brought up by counsel about the ability to be able to have unrecorded private conversations during a hearing is fundamental to the defense of this case, and it's also fundamental to the state in order to present their case. And so no matter how highly trained or technical these people are, they're not court employees, they're not court personnel, they're not subject to all the rules that a lawyer would be subject to. And if they go outside of the scope of that, this information gets leaked and blasted out to, as Ms. Wong says in her affidavit, millions of people, then the bell has been rung, it can't be unrung, and we could end up with a mistrial in this case or other consequences. And so it's a huge concern to me. And I'm just telling you, I'm not inclined at all to outsource the important responsibility of reporting to a third party with just an understanding that they're trained and they'll do the right thing and trust us.
Well, and I appreciate the court sharing its perspective. I guess I don't see it that way, and perhaps I'm missing something, because when the court grants what it grants, as far as cameras and microphones, I realize two different issues, but related. In the courtroom, it is not simply reliance on in good faith. I understand the point about if that happens, then it's out there. But there is a distinct party that is subject to the jurisdiction of this court to pay the consequences of such an action. It is not simply a reliance on good faith. They're submitting themselves to get that approval to the orders of this court and the ability and the consequences for failure to comply. I know there is a temptation, not necessarily by the court, but I know there is a temptation to assume the media is simply out to get whatever it can get. This is not, and of course I don't speak for all media. I speak for my clients, and I in particular speak for those who have been granted or even will be granted pool coverage. These are professionals. I understand, I'm not trying to quibble with the court's point about there's still third parties, but these are professionals who are among the best at what they do in difficult situations like this. The arrangement that was granted, as Ms. Wong states in her declaration, is not unusual. That doesn't mean this court is in any way bound by it, but it's not like this court is just turning over control and hoping things go well. There are professional and very directly judicial consequences if they don't follow the law and the orders of this court just as much as anyone else here. So I do respectfully disagree that this is simply a matter of turning it over and hoping things go well. And indeed, I would respectfully submit, Your Honor, both with regard to cameras and with regard to the microphone, that these microphones are more capable of siphoning out inappropriate information. As the court knows, and I stand corrected.
Who determines what the inappropriate information is? Do I get to make a determination on that? Does counsel get to weigh in on that? Or does someone that works for one of your clients with a set of headphones on make that decision? And I have no idea what their training is or understanding of the rules of evidence or the rules of privilege that exist amongst attorneys and their clients.
Well, respectfully, Judge, I don't think it's that difficult. Any communication at the table is confidential. Any notes on the table are confidential.
That's also not true, right? Because clients can talk out loud to attorneys, and if they do it in a public setting and everyone hears it, and I've seen it before in criminal cases.
Sure.
Defendant blurts something out to their lawyer. I hear it. State hears it.
Right.
They shouldn't have said it. They waived the privilege.
Sure.
So I would say there is a determination that needs to be made each time. And again, these are decisions that how am I to have faith and confidence that whoever's making that decision is making the correct legal decision?
Well, perhaps the court can help me understand. I'm a little confused by the example, because if the
Well, I was
defendants
just
were,
pointing out, you said all communications are confidential and privileged, and they're not necessarily, that's not always the case.
well, that's fine, but that's not the point. If my clients treat those, I mean, if something is blurted out and said, it's heard, it has nothing to do with whether the media had something to do with it or not. My point is that it's treated, those communications are treated as confidential, period. Period. There isn't a determination to make, oh, maybe we can listen in on this one and not that one, period. They are confidential. And they're not.
That's a standard your client implies. Is that a written policy they have somewhere, or is that your representation after talking to them?
Okay, thank you, Judge. And it's a representation I'm happy to make after communicating with them, and would be happy to make or submit a declaration or affidavit to that effect. That I mean, as far as the cameras go, I want to make sure I'm tracking with the court's concerns, because that's what I need to address. But as far as the communications go, other than a concern that something might be overheard, that we are affirmatively telling the court will not happen. And the training, and it's not just some training, I mean, it's better training than I could do. I mean, that's the purpose. The reason for being here is to ensure that we comply with the court's order. And communications at the table are treated, maybe that's the better way to say it, treated as confidential. If they blurt something out, that's beyond your or my control. But they're treated as confidential. They are not recorded. What the court hears when it reviews that the broadcast that was submitted, I believe, by the state, it will hear what was recorded. It's the same thing. There's no editing, there's no filtering, because all of the effort is placed here in the courtroom to ensure that compliance. Does that help the court?
It does, and I do appreciate the way you answered and the responses to my questions, Mr. Wright. I'm not trying to go out here. I just have some very real concerns, and I do appreciate the way you responded.
Of course, because if the court has concerns, I want to address them. I totally agree. I take no offense, and certainly hope I haven't argued with the court at all. My goal has truly been to respond to those concerns. But those concerns are based on what we think is an overbroad approach to shut down pretrial publicity and frankly to accuse the media of some wrongdoing that it simply didn't do. If the court, we have no objection to the court reviewing, it's open to the public. The court should, of course, be able to review that information. That's the very purpose. And if the court sees I have a concern, or even that the camera was located where it was. Again, the point is it's within the court's control. We just ask that the court continue to exercise the control that it has. The arguments, at least in part, seem to assume this court isn't in total control and these things are just kind of happening, or more importantly, might happen. And that's simply not true. This court, the media will follow what this court directs, of course. If I may just look, see if I have any other comments. I may have a moment. So I'm not sure if I addressed this, John, more the technical aspect. With regard to multiple cameras, again, the goal is to avoid distraction. So the reason for multiple cameras, whether it be 2 or 3, we respectfully submit 2 or 3, especially as they are used, it does not create a distraction. The reason for that is our goal is not to move them. And so if the camera is showing something and say a confidential communication occurs, I've addressed already how the microphone it is shut down. And again, what happens, what's recorded is what's broadcast. So the court would know if there's a problem there. But that allows us the ability to immediately go to another camera, taken off whatever might be a confidential communication or whatever the court determines is inappropriate. And so there is actually, where possible, a need for multiple cameras, because we don't, I'm sure the court doesn't want to see distracting cameras panning or moving around. And yet we need to be able to get off whatever it is that might be an inappropriate thing to show. So I hope from a technical standpoint that provides the court some guidance as well. And recognizing the court's concern about third parties' involvement, I want to point out that if the court's sound system is used, if anybody says anything into the microphone, it's picked up for better or worse. We actually have the ability to control and make sure that doesn't happen. It also, and I don't know about the quality here, I don't mean to impugn it at all, but the quality of the audio is important. FCC standards require a certain level of quality for closed caption, things of that nature. And again, these things can all help facilitate what we believe is the court's correct balancing of these interests. When I say balance, please don't misunderstand that I'm trying to say somehow the defendant's rights need to be sacrificed. What I'm saying is they can be balanced without sacrificing those rights. And I respectfully submit that going to the other extreme of banning cameras from the courtroom, whatever the court might do or was requested with regard to microphones, actually interferes with that rather than helps ensure the decorum the court demands it is in fact respected. Did I mention if at least Court TV has the ability to provide mutable microphones if that's something that the court wants. I would suggest, Your Honor, not that I don't know what relevance it has to the court, but we respectfully disagree that there was some unusual happenings that occurred. For a high profile matter, even the camera placements and the microphones, as Ms. Wong states in the declaration, who's been involved in many of these matters, was not unusual. That isn't somehow binding on the court, but I just want, I want to respond to this idea that what happened on August 16th was an atypical situation. It was a typical situation for atypical circumstances, if I may put it that way. I guess in conclusion, Your Honor, I am concerned when this motion is used as a means to attempt to curtail pretrial publicity, when the United States Supreme Court has indicated that there are other means to do so. And I know the court knows this because the court has thoroughly considered those issues in the decisions that it's made. The pretrial publicity won't stop. The accuracy of what happens in here or how it's reported may be hindered.
What about the volume
Of the interest?
of the publicity?
Again, I'm not sure.
In other words, if you can read about a hearing in the newspaper versus watching it live on social media, what do you think is the volume of one versus the other?
Well, I guess that's what concerns me, Your Honor, is when the purpose is to control the spigot in a way that says, well, we'll be able to tamp it down this way, because if we do it this way, more people will watch. The level of interest, it is not based on the media. It is based on the circumstances. And I respectfully submit to the court that when the court looks at trying to
On the flip of this, right? The media, they promote certain stories. I know this. I can have a routine standard hearing. In this case, we have I know it goes out on tons of media outlets and it's publicized everywhere and it's promoted. And 2 weeks ago, I had a change of plea hearing in Madison County where someone pleads guilty to a murder charge. Not one reporter or that I ever saw in the local news, I occasionally got a story on it all. So sure, certainly publicity and promotion of that publicity go hand in hand. And the concern here again is we're not to trial yet. We've already had to transfer venue because of the publicity and the promotion of that publicity. And what's wrong with considering that we need to try to control that so we can get a jury pick that hasn't already made up their mind and make us have a mistrial for not having enough jurors that have already been tainted by pretrial publicity.
Well, of course, the court is correct in its concerns, and I don't have any argument with that. My concern is in the way that the court's concern is addressed. Simply assuming that because there is publicity, even internationally, an Ada County jury can't be found, I think is a reach. Other than just the general premise that the more people hear about it, the more possible it is that there will be people that have prejudged the case. That's like taking a sledgehammer to an issue where a scalpel is appropriate. And so I recognize the concern. Do not quibble with it at all. My concern is with the manner in which it is addressed. And I do respectfully come back to the idea to say, well, if you want to know about this case firsthand, then you must physically come here. Otherwise, you'll rely on the reporting, which won't be as accurate by definition as the firsthand experience, which is within the control of the court. Have I responded to the court's question?
Yeah.
Okay. I appreciate again the court's time. We respectfully request that this motion be denied because the power always has been within this court and has been appropriately exercised. And if the court determines there's an adjustment on fine tuning some of the things that it will permit, we respect that. Our concern is what we think is a vast overreaction to appropriate prudent conduct of the media that will hinder what we still feel is an important function that doesn't have to be sacrificed to ensure the defendant's constitutional rights. Does the court have any other questions for me?
I don't, Mr. Wright. I appreciate your professional your arguments today, responding to the questions.
Thank you, Your Honor.
Counsel, Mr. Archibald, Mr. Wood, the court engaged in quite a few questions with Mr. Wright and indicated some of my expressed concerns here. If you'd like, I would offer you an opportunity to respond. They will have a rebuttal argument if you like what Mr. Wright's offered here. Mr. Archibald, is there anything further to like that?
Just briefly, Your Honor, the media's argument that we were in compliance with court orders is exactly the problem, because the orders weren't specific enough as to what they could do and not do. So we let them police themselves. And when we let the media police themselves, what did they do? They put microphones on our tables, put a camera right in front of us. It had not been done in any other hearings, which I have never seen. And so that's why our motion to clarify, so that the court can, as Mr. Wright suggested, take a scalpel to this order and say no cameras zooming in on the defendant, no microphones on the table, no live feed. The court does have the discretion to modify these current court orders. These current court orders are forms. They're used in routine cases. And again, I've never had to ask for a modification because we in the past have been respectful of each other, and they just crossed the line last year. That's why I brought the motion.
All right, thank you, Mr. Archibald. Mr. Wood, with state by talking or vote.
Just briefly, Your Honor, to the state, compliance isn't the issue, it's just affects back to trial publicity. At one point, I think Mr. Wright did say that the harm was an assumption. Well, it's not an assumption. The taxpayers in Madison and Fremont County were paying a lot more for this trial because of pre-trial publicity. That is not an assumption. And so I do take issue with that. I won't comment on the issue with the microphones anymore. I think the court's comments show that it understands at least our concerns. I guess the only thing I would add is if the state still believes that the best remedy is simply to remove video cameras from the courtroom. If the court decides to take a different approach, we would request that the state and the defense be put on notice as to the location of the cameras before any hearing takes place.
All right, thank you for your comments, Mr. Wood.
I just didn't have permission to be excused unless the court was going to rule for me.
I don't intend to rule from the bench, Mr. Wright, so you be excused. Thanks for your grace.
Thank you.
Also, I've considered this issue needs to be under advisement because it would result in a ruling regardless of future effect on how these proceedings take place, and needs instruction on what we will or won't allow in terms of cameras and like third parties and forward for future proceedings. I'll be considering that both in context of pre-trial motions and the trial itself. I'll carefully consider these issues that have been raised, and the court will issue a decision. That concludes our hearings for this morning. And Mr. Archibald, anything further from the defense?
No, Your Honor. Thank you.
Mr. Archibald, Mr. Wood, any further from the state today?
No, thank you, Your Honor.
Okay, thanks everyone for recess.
All
And there you have it. This was a motion to prevent cameras and news outlets to be in the trial. I apologize, I totally missed the first hour of this hearing. So if you're interested, I'm sure there's other channels that have aired it. But I guess the judge will wait another few days before he makes his decision, and then I doubt they'll have another hearing just to hear the decision. They'll just probably post it, and I'll put it on my community tab. So be watching for it. Thanks for watching.